I would like to introduce the moderator of this panel, Dr. Pramod Tiwari, Associate Professor, Senior Scale, Faculty of Law, Delhi University. I would request you, sir, to kindly address.
Very good morning to one and all. First of all, I am thankful for this Bar Council to invite me as a moderator for this session. And the topic which has been selected by this organization is wonderful. Jan Vishwas Act 2023. Very recent topic and very relevant. On this very special day of Constitution of India, they have selected such a wonderful topic. And before coming to this particular topic and the pros and cons which are involved therein, let me congratulate you all for the spacious occasion of Constitution Day, which is celebrated by this Bar Council. Let me have a little glance over this particular legislation which has been drafted. Jan Vishwas Act 2023. The very title of this legislation is wonderful. Jan Vishwas Act. If you take the meaning of the short title, Jan Vishwas, the genesis of legislation should create faith to the people of the country. Any legislation whatsoever must create faith in the people of the country. If you have a glance over various schools of jurisprudence, which has been evolved by many scholars, the faith of the people is the cornerstone behind each and every legislation. Let me quote Savini, who is the scholar of historical school of jurisprudence. And he has given the concept of walk gist. What should be law? Law should be walk gist. So in this way, Jan Vishwas is a sort of walk gist. Unless and until faith and gain of the people has been covered by any legislation, cannot survive in a particular country. So this is very important that this legislation which has been selected for this institution to be discussed here in this forum is very much in consonance with the jurisprudential philosophy, that is walk gist. If you have glanced over historical school also, they are talking about public interest. If there is clash between public and individual interest, then public interest must prevail. It means again there should be the faith of community in the law. So in this way, the title of this legislation which has been selected for this session is wonderful topic which covers many aspects of jurisprudential component. Over and above, if you have glanced over Constitution of India, and the preamble of Indian Constitution has been discussed by many dignitaries in the inaugural session. If you have a glance over, there are many objectives which have been enshrined in the Constitution of India: justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and opportunity, so on and so forth. If you have the very meaning of this, the title of this legislation which has been kept for discussion incorporates all these objectives of the Constitution: justice, fraternity, liberty, equality, so on and so forth. So in this way, the legislation which has been selected for this particular day is wonderful. Now come to the little bit few provision of this legislation, Jan Vishwas Act 2023. If you read the preamble of this legislation, the preamble talks about why this legislation is. This legislation is to decriminalize and to rationalize. If you read preamble, only two-line preamble is there. To decriminalize and to rationalize various offences in India, and also to create trust-based faith to the people of India regarding legislation. The very preamble of this legislation also in consonance with the jurisprudential and constitutional philosophy which has been incorporated therein. And by this legislation, particularly the enhancement of punishment in various acts and legislation has been ensured. I have seen many legislation which has been amended by this particular Jan Vishwas Act 2023, and by this legislation enhancement of punishment, penalty, etc. and etc. has been made up. A plethora of legislation has been amended. Now although this is very good, the quantum of punishment should also keep pace with the changing need of time. There should be quantum of penalty which must एटलीस्ट शुड नॉट बी मॉकरी इन द सोसाइटी। कम से कम उसमें इतना जरूर फेथ हो कि हमको लगे कि नहीं, पेनल्टी तो इम्पोज करी गई है एंड विच हैज बीन पेड बाय द पर्टिकुलर इंडिविजुअल शुड बी एट पर्टिकुलर बर्डनसम। So in this way, government has we should welcome this step of government wherein the quantum of punishment has been increased by the government of India by this particular legislation. But at the same time, mere increasement of the quantum of punishment and penalty does serve the objective of legislation? To me, being the student of law, perhaps not, because we are not following the deterrent model nowadays. Nowadays, we are following the model of reformation and preventive model of criminology. So that is why, in this sense, mere increasement of quantum of punishment in a particular legislation, I personally think doesn't serve any purpose. Rather, there should be certain model of reformation and prevention also. So in this way, I may put certain critique over this particular legislation. So with this background, we are going to start this discussion, panel discussion in this topic, means Jan Vishwas Act 2023. Thank you very much.